Hey, good afternoon. It's May 28th. This is the conference committee for S.208. And we in the Senate asked to form this conference committee because we have some concerns with what was sent over from the House and the amendments that were proposed to our bill that we sent over to you. I mean, right off the bat, I feel like what was provided is essentially what law enforcement has testified to that they're doing already, which is developing a model policy regarding law enforcement identification standards. That was at least the testimony we got earlier on in the year. And so, I mean, at this point, with what was sent over to us, it feels as if, regardless of whether or not it passes, same model policy is going to be made. Happy to stand corrected, but it's our position that we still maintain in policy some law enforcement identification standards that include local, state, and federal agents to prohibit masking in some capacity. And that's our position at the moment. Have it here from you as well.
So as you are probably well aware, of the reason that we did this wasn't just for the Ninth Circuit case. I think really early on when we first took a look at this, legislative council, Sophie went over kind of the state of the constitutional issues at that point, and could look at the district court opinion at that point, which found this to be constitutional, essentially equating it to a traffic law, the masking law that is very similar there. But then the Ninth Circuit reversed that, and that caused us not just relying on the Ninth Circuit opinion, but that really said, all right, we need to look at this more deeply to see really where we think this is constitutionally. And we reached out and had conversations with Attorney General's office, with legislative counsel. We had Professor Rodney Smola, an expert in constitutional law, has been practicing it for 45 years, to really dig a little deeper on the constitutional issue. And the bottom line is we felt that it's highly likely, it's a different circuit, understood, but highly likely that this would be found unconstitutional. And we felt that in this committee that because of that, we needed to take the feds out. But we'd also heard during the course of the testimony that this was an issue with respect to local and state as well, that having a standard for them is important. We did not get the impression that they were going to do a model policy until we all asked them to. And we did change it to the Law Enforcement Advisory Board as really being the experts, because I don't think that's what we had before. So that's where we ended with this, and we really feel that we should be putting our resources on defending our laws elsewhere where they're defensible. And I just don't think this one was defensible. Could be proven wrong. I don't think so, but and again, not because of just me, but because of the other input that I received from, for instance, Professor Smola. So that's kind of where we are. But as far as looking forward, I mean, yeah, all right, maybe I'm going to be wrong. Maybe I'm going to be proven wrong, and we're going to probably find that out relatively soon, because Connecticut, as you mentioned, or I don't know if you mentioned, or just generally known, yeah, I keep on hearing that it's Connecticut has passed a law. New York, have they passed the law all the way through, or is it in the governor's desk or something like that?
Well, the governor did a press conference saying that in the budget bill, they were going to be including the language that we've got, like in S208, S209, and the Congress 1983.
Okay, so it's not all the way there yet, but it will be there. So the other two states in the Second Circuit, almost certainly the feds are going to, they've been making that noise that they will be challenging it, like they have done in New Jersey, like they did in California. And we're going to hear, in fact, whether, in fact, this can be constitutional. So if we did the policy, if we were doing the policy and had that promulgated next year, and if we find out in the interim that, oh, this is in fact constitutional, then we would be in a position where we could essentially make the policy into the statute again, and then hold the feds at that point. So I think having the policy work, the model policy work done in the interim or right now until the legal standards are clarified a little bit better. I think they're fairly clear myself. Yeah, that is advancement. That is advancement even with respect to the federal agents, because we can put that in place later.
Yeah, I think, I think there are persuasive arguments on both sides, and I think that, I hear where you're coming from with regards to Professor Smola. We also heard from Professor Jessica Bowman-Posen. I think you may have heard from her as well.
Yeah.
And so I get that. I mean, there are always going to be scholars saying one thing or the other thing. Personally, I do have some concern with legislating based on decisions from appellate courts that, in which we're not in a jurisdiction. For example, there have been 2 different courts that have overturned language related to waiting periods and magazine bans, and yet we still have those on the books. And so, I think, just relying on what has been established in the Ninth Circuit isn't the best way to go, but, you've also heard from scholars, so I get where you're coming from. I do think that ultimately, well, as you know, it's the Supreme Court that will ultimately decide whether or not this type of policy would be constitutional or unconstitutional. And so, I'm not inclined to just preemptively step away from such a policy until the Supreme Court has weighed in, which, as I said, I'm sure they will in the next year or 2. So, I hope perhaps there's a way to find a middle ground. And, we all have some ideas floating around. And so I think maybe we'll want to talk with Ledge Council, take a break and try to figure out some drafting language perhaps.
Okay. No, that makes sense. I think it's important for us to kind of set forth where we are right now, and let's see if we can figure out the path forward. Okay. I'm fine to do that. And should we schedule time to meet again this afternoon?
We're back on the 42.
We are, but we're not gonna have a lot that we can do, so probably by 3:30 would be.
Okay.
out.
Why don't we shoot for 3:30?
Does that give legislative council enough time to work on it?
That it is.
All right,
I will do the best
let's
I
say
can.
tentatively 3:30. How about that?
Yeah, that sounds.
And back here,
And back, sure.